Good afternoon. Thank you very much for the invitation to the organisers. I don't think Sophie is here. She was explaining that gas disputes was the sexiest, or probably not the sexiest topic. Well, I'm about to beat Sophie's topic. So I'm going to talk to you about artificial intelligence and third-party funding. Never have two phrases been so unwelcome as exam and dentist. But if you know about artificial intelligence in the realm of third-party funding, then you're either a supreme nerd or a third-party funder. And I include myself and Hugh in this topic, because Hugh confessed that he's also very interested in this topic. And so I'm looking forward to any of his contributions later. Let me explain some fundamentals, because I don't think we should ever assume anything. Third-party funding, just let me explain what it is, because you may well be familiar with it. It's been a hot topic for many years in arbitration, and some of us have grown a little tired of third-party funding, but it's a necessity. It's rather like your greens. You have to eat your greens, or you're going to be told to eat your greens. And now increasingly clients are telling us to get involved with third-party funding of their own initiative, because third-party funders are reaching out directly to clients. Now, don't think of third-party funding as like eating your greens. Think of it as Moneyball. I don't know if you remember this movie with Brad Pitt and the Oakland Athletics baseball team, where it was all about on-base percentages, looking at statistics as to who's going to get on first base and therefore be the most successful team. Well, the same is now that could be said of artificial intelligence in the realm of third-party funding. Third-party funders are the providers of funding who will fund your case. They will provide funding for the lawyers who will represent you, and they may also provide funding for a portfolio of cases. That's to say, a number of cases that a law firm or a client may have. Now, that's important because the third-party funder will get some share of any compensation. The claimant obviously has the access to justice, has access to lawyers where they may not otherwise be able to afford it. And of course, the lawyers benefit because they may be able to get a proper fee rather than having to work at a lower rate. Now, third-party funding can take many forms. Of course, financiers are very creative people. So not only can a single case be funded, but the downside of losing a case can be funded and can be insured against. Multiple cases can be funded, and portfolios, as I said, can be funded. So a funder can come to you and say, you've got 20 cases, we're going to assess them all and give you money to run them all. Some will be winners, some will be losers, and we'll come back to that in a moment. But it's huge business, and I'll come on to exactly how big a business it is in a moment. Now, I want to describe a little bit about what types of artificial intelligence there are and how they come into play with third-party funding. And then I want to finally comment on what all of this means to you. What is this? How is this going to impact you, assuming you're practicing in the field of international arbitration? So firstly, about artificial intelligence. So recently, 20 US-trained lawyers with decades of experience and various particular expertise in contract disputes were given 5 non-disclosure agreements to analyze. And they competed against a system called Law Geeks, Geex. Now, this had been developed over a number of years, and it had been trained, the system had been trained to look at contracts. Now, the research was to compare them and to see what legal issues would come up. Now, after extensive testing, Law Geeks achieved an average rate of 94% accuracy compared to the experienced lawyers who achieved only a rate of 85% accuracy. Now, AI is predicting outcomes of cases, predicting contract issues, predicting patterns, judicial and litigious tendencies. They're looking at the behavior of judges, the tendencies of judges and arbitrators. They're predicting timing of cases and of motions, how long it takes to go through certain phases of a dispute, and also predicting remedies, how certain courts or arbitrators will rule. What is their tendency? High compensation, low compensation, split the baby or not. Now, these algorithms can be very powerful. And there's a few systems, Ravel Law lex machina, lex shares. Lex shares is one that I've sort of consulted with a number of clients who are involved in third-party funding, but they're banks who are now getting into third-party funding. They will use lex shares quite substantially. And Gabalytics as well is another system. A lot of them are scraping data, looking at the performance of judges, cases, and also counsel. And this is an important piece for third-party funding. So how about the use of artificial intelligence in third-party funding? How does it work? Well, the particular use of AI is, for a third-party funder, important as to how to price a project. If you're going to fund a project, how much money are you going to give to the lawyers, to that client? $1 million? $10 million? So the pricing is critical. Underwriting is also important. And this actually was the first word that came out of every client's mouth when I asked them, how do you employ AI in your third-party funding work? They all said underwriting first. That's to insure themselves. That's in case there is a loss, in case they get it wrong. Of course, they have to cover themselves first and foremost. The portfolio assessment, as I said, is important. Law firm performance and how lawyers behave. Are you a successful lawyer? Will you win a case or will you lose a case? And obviously, as I said, arbitrators' tendencies and tribunal tendencies. That's to say, a combination of arbitrators. How may they perform together? Now, these are critical variables that go into deciding for a funder whether you have a winner or a loser for a case. And as I said, it's huge business. And let me explain quite how big it is now. Because no longer is it the binary case of, are we going to fund one case, yes or no? There's now really like a subprime market for funding. Now that didn't go too well, so we won't use that phrase again. But the idea is that you collect cases. Funders have a portfolio of their own cases, and then they are selling that debt to a next secondary level. It's syndicated. So you have funds sitting above the third-party funders who are acquiring that debt. They're acquiring that risk and potential return. So AI is now being employed by those funds to understand whether or not the portfolio that they're buying a tranche of will actually be a successful return. So then you can begin to see that this is now, we'll use it again, like a subprime of debt and perhaps an approximation of risk rather than just a specific, I'm going to ask you to give me a risk assessment on this case. It's now getting spread across many different cases. So what about AI in third-party funding in international arbitration? Now, the assessment of data is difficult in arbitration because in court litigation, you have public information in arbitration, particularly commercial arbitration. It's not always public. And if it is, it's going to be incomplete. Maybe redacted awards, maybe partial publications of awards. So there's an inability for us to use pure sets of data for this sort of analysis. But this is changing. And for example, Global Arbitration Review has an arbitrator database now. You're looking at the profiling of arbitrators, how they behave. You've got examples of their decisions, examples of their procedural orders. You can glean a lot from this kind of database. Professor Catherine Rogers from Penn State had put together Arbitrator Intelligence, a similar database. Some people don't like it, some people do. Third-party funders and the use of AI love it because it's profiling risk. And there are, of course, multiple websites. We see much more commercial arbitration decisions being published. You see blogs, you see the Intelligence, Investment Arbitrator Reporter, for example, in the investor state sphere, are real time. They get it before the broadsheet newspapers get the news. So you have a lot of information flow. Now you might think, God, this is all so mercenary and horrible, and you're muddying our hands when we're in the cathedral of law here at Oxford University, and we should be thinking of pure jurisprudential analysis. But don't be too quick to judge, because of course that funding can be employed in a very important way for access to justice. There are many, many people who can't afford to arbitrate. International arbitration is, of course, a cross-border means of dispute resolution. That means you may have, in much the same way we would look in economics terms of a north-south divide, you may have that. And you may have a company with very few resources, unable to take on the Goliath in their contract dispute. So third-party funding is a way of allowing that winning case to get off the ground. Now, the third-party funding task force, ICA and Queen Mary, put together a report which came out earlier this year, and I would suggest you read it, from April of this year. And it was interesting. I won't read the extract, which I was going to read, because I'm probably going to get told off soon by Anna. But the report was interesting because it was very open in its assessment that third-party funders not only look for winning cases, they will assume the risk of losing cases in that portfolio acquisition. So you buy 20 cases, 15 may be winners, 10 may be winners, 5 may be winners. But what you will recover on those 5 will offset the losses that you may well be funding for the other remaining number of cases. But think about that for a moment. Is that right? Is that fair? Is that the right employment of money in dispute resolution? Because what is that? That is saying that we're going to fund losing cases. You're going to take someone to court or arbitration which you don't think you're going to win. And we should ask ourselves, is that right? Is that an appropriate use of resources? It is, de facto, a way that things are moving forward. And it's no secret. And funders are unapologetic about it. And like I say, maybe the upside of access to justice means there has to be a downside. But let me then just conclude as to how this is all going to affect you. And that's one of the first obvious areas. If you're a practitioner, you may have the opportunity to run cases which normally you wouldn't. You may normally tell a client, this is going to be a losing case. But how will you be influenced if you have the funding to run that losing case? We all have that certain ethical obligation, that professional obligation, but will that be diluted by the access to resources that third-party funders can offer? Now, the access to justice, like I said, is one way that AI will improve the assessment of risk, because with greater certainty comes greater appetite to assume risk from third-party funders. Strategy will also be informed by third-party funding and AI. Third-party funders are often quite involved in strategic decisions. With AI, that will become more acute. How to play the role with certain arbitrators. What do they like? What do they dislike? What methods work? Strategically, what is the right approach? Legally, what is the winning outcome? The whole algorithm you can see through a case will become better mapped by AI. There are third-party funders who very openly say in their pitch, more money spent on your legal fees will give you a greater chance of success. Of course, it's a self-serving comment, but it's also a very simple analysis of output equals input. So this is going to affect the way you practice in arbitration. And then also cognitive computing is looking at strategy not only at the dispute phase, but at the commercial phase. So normally if you're a lawyer and you're advising a client, your instinct is to try to avoid a dispute at all costs. And we all run this sort of slightly schizophrenic way of working with clients where we recognize their commercial interest is to avoid arbitration. If we turn up, things are going horribly wrong. Of course, there's a motivation to go to arbitration. It's natural, it's our business. But now with AI, there are methodologies being employed to look at how you would maybe want to go to arbitration, because the AI mapping of your risk is actually favorable. So this is impacting now, and there are examples in the press and in the stratosphere of AI commentators that the whole commercial assessment of risk is changing significantly. And then finally, how else is it going to impact you? The final word I'll say on this is you, whether you get hired. People will know whether you're a successful lawyer or not. You as an arbitrator, whether you'll get appointed. And the combination, counsel with local counsel before certain arbitrators, the sophistication continues. So there are skeptics, I'm one of them, about how much information is actually reliable. I'm a skeptic because of the limited information we have in arbitration. It's not a complete universe. But reliance on historic data is already taking place. And with the systems that I described at the beginning, it's already being used by these funders. So it'll be landing on your desk pretty soon as well. Thank you very much.